So one of the major advantage of private companies is to protect the relationship of family members. Woo! Hi guys, you're welcome to my Read With Me series. Even if you have private company limited by shares, private company limited by guarantee, and private unlimited company, section 22 subsection 1 of the CAMA strictly or basically emphasizes on private company limited by shares. So that's what we'll be treating now. So under a private company limited by shares, we're going to look at section 22 subsection 2 paragraph A, which provides that a company shall not sell any of the company's assets having a value of more than 50% of the total value of the company's assets without directly seeking the consent of all its members. Section 22 subsection 2 paragraph B provides that a member of a company who wishes to sell his shares in that company must first offer that shares to the existing members of the companies for sale, and then if they refuse to buy, they can sell to an outsider, which is a non-member, and this is called the right of first refusal. You get me? So if a member of the company wants to sell his or her shares, he must first offer the shares to the existing members of the company for sale, and it is only upon refusal to buy the shares by the existing members can that member offer to sell the shares to an outsider. Yeah, this brought about the right of first refusal because, as we all know, one of the major advantage of private companies is to protect the relationship of family members. Woo! Yeah. So section 22 subsection 2 paragraph C provides that a member or a group of members acting together shall not sell or agree to sell more than 50% of the shares in the company to a non-member unless that non-member has offered to buy all the existing members' interests on the same terms. What this means is that if, for instance, Mr. A has 50% shares in a company, Mr. B has 15% shares in that same company, and Mr. C has, let's say, 35% shares in that company, Mr. A and Mr. B can only come together to sell their shares in that company if the person that they are selling to, which is Mr. D, has accepted to buy the shares of Mr. C on the same terms at which he has bought the shares of Mr. A and Mr. B. Makes sense? Yeah, the rationale behind this is because in a company, most important decisions are usually based on the opinion of majority shareholders. So, yeah. We're done with section 22 subsection 1. We're done with section 22 subsection 2, paragraph A. We did paragraph B. We did paragraph C. Right? Now we're in section 22 subsection 3, which provides that, generally speaking, the total number of members of a private company shall not exceed 50 persons. However, these 50 persons do not include those persons who used to be employees in the company but are now shareholders as a result of their invaluable contribution to the company's growth or by acquisition of shares in the company. This set of persons are not included in the 50 persons required by law. Okay? So guys, section 22 subsection 3 is saying that employees who as a result of employee profit sharing scheme became shareholders of the companies are exempted, or members who bought shares but are no longer members are exempted from these 50 maximum shareholders. Got it? 22 subsection 4 provides that when two or more persons hold one or more share in a company jointly, they shall, for the purpose of this subsection 3, be treated as a single member. Some persons may usually not be able to afford a single share of units in a company and may decide to contribute with one or two persons to buy. For this purpose, those who contributed to buy will be regarded as one person. Yeah, basically you get that. That's just 22 subsection 4 is just saying that where two persons come together, when two or more persons come together to acquire a particular unit of share, to be treated as one person, as long as they're buying that share as one. 23. Section 23 now provides that when a company defaults in any of the provisions of Section 22, the company shall cease to be entitled to the privilege and exemption conferred on private companies by or under this Act. And this Act shall apply to the company as if it were not a private company but a public company. So basically, if you're a private company and you default any of the provisions of Section 22, you would be treated automatically as a public company and not a private company. Yeah. So, reason as to why if you're a private company and you act like a public company, pursuant to Section 23 of the CAMA, you default the provision of Section 22 of the Company Allied Matters Act, you will be automatically treated as a public company. And the reason why this is a punishment is because basically a private company is just the opposite of a public company. So if you start defaulting, that means you are telling us that you're a public company, so you'll be treated as such, and it's a punishment because trust me, you don't want that. Yeah. So however, subsection 2 of Section 23 provides that if the company is able to convince the courts that its non-compliance with that Section 22 was a result of an accident or other equitable grounds, such courts may decide to waive the consequences for the company. And we can see the case of Stella against BGL Limited. In this case, BGL Limited is a private company who invited Stella to come and invest in the shares of the company. She invested over 14 million. Stella that came over invested over 14 million. The company overtook private placement to raise securities for the company. And this is not supposed to be done in a private company. It then happened that the shares of the company became worthless and Stella lost her money. She went to the tribunal and the tribunal told her that the Securities and Exchange Commission, which is the SEC, is only empowered to regulate the securities of public companies. And because the securities Stella invested in were securities of a private company, therefore she had no remedy under the law. This decision by the tribunal can of course be said to be a faulty one. The reason is because it can be argued that in this circumstance, Section 23 of the CAMA came in because the moment BGL Limited floated securities, that has publicly offered their shares for investors to buy, they violated Section 22 subsection 3 of the CAMA, which prohibits private companies from offering their shares. Yeah, I said that earlier. They're not supposed to offer their shares as a private company. That's what a public company should do. Yeah, they violated Section 22, which prohibits private companies from offering their shares to the public. And the moment they did that, the law to that effect is that they will no longer be treated as a private company, but rather a public company. This now brings BGL Limited under the purview of the SEC. Makes sense? Makes sense.